Good morning, everyone. Welcome. Thanks for joining us for the first webinar in the series of webinars that will be presented this year by Pro Seniors and the Ohio Department of Aging. This is a series of webinars on elder law topics, and today the first session will focus on institutional Medicaid. Before we get started, I have a few housekeeping tips to share. First of all, we have 1.5 hours of CLE credit approved for this session. To receive that CLE credit, you will need to participate in the polling questions when they pop up. If you are unable to put the answer in the poll, feel free to put your answer in the chat and we'll still count it for you. You'll also need to do a survey that will pop up at the end of the webinar when we close out. The Zoom survey will pop up. If you don't see it, we can also follow up with a link for you to still complete the survey. We will send out attendance certificates to everyone next week. So if you don't need attorney CLE credit, but need credit for some other purpose, hopefully that certificate and a copy of the agenda will work. If you need more information, let us know. And then we will also provide the materials folder again to you in the chat in just a moment. In that folder, you'll find the PowerPoint for today. And after the session, that's where we'll also put the recording for today. Questions during the presentation, feel free to put them in chat or in the Q&A. We'll be monitoring that and let Miriam know when she gets to different breaking points in her presentation if there are questions for her. So with that, I am happy to introduce Miriam Sheline from Pro Seniors. She is the managing attorney there and our presenter for our session today. So Miriam, take it away.
Thank you, Melissa. Good morning, everyone. So great thing to spend 90 minutes with me on elder law topics. I appreciate everybody joining. What we will be doing for these first two sessions are we're going to be talking about institutional Medicaid or nursing home Medicaid. This is similar to the presentation. I'm going to do a little more deep dive, but generally one we do for our nursing home social workers and our helpline attorneys, et cetera. So for those who are joining us that may be regular social workers with AAAs or our ombudsman, it will give you a good overall flavor of the issues that you need to basically look out for. The PowerPoint document that you're going to have is going to be a good reference to you for future use. But we're also going to get into some some examples, et cetera, to sort of walk everyone through, including our attorneys, on how the nursing home Medicaid piece works. So with that said, let me talk a little bit for those who don't know what Pro Seniors is. Pro Seniors, we have a statewide legal hotline. So our legal helpline served over 12,400 appointments last year. Any senior 60 or older, or anyone on behalf of a senior 60 or older, can call, talk to our intake, and we'll get scheduled with a 30-minute telephone appointment with one of our attorneys for free legal advice on any issue. Obviously, one of the big topics we talk about is nursing home Medicaid. So that is going to be a resource to all of our social workers out there when they have clients who are seniors and need some legal advice as to how to direct them in the right direction. So in addition, part of the ombudsman's for Southwest Ohio here in Pro Seniors, we have Senior Medicare Patrol, and we have a pension rights project where an attorney works just on pension issues in the region, which includes Ohio, Pennsylvania, Kentucky, and Indiana, I believe. So with all that said, let me get you started on the actual Medicaid. So our institutional Medicaid is usually a 3-hour presentation. We are going to break that into 2 sessions. Today, we're going to talk about income and resources. And then in 2 weeks, our second presentation will be on the more in-depth parts of resources and asset transfers and penalties related to that. And then our third session, I believe, is on Medicaid estate recovery. So as Melissa said, I will stop in sort of each subsection to see if there's any questions. So feel free to add those as we go along. Okay. All right, so let's get started a little bit about Medicaid, what it is. Okay, it is a joint federal and state program. The federal government pays a piece and the state pays a piece. The state doesn't have to join, but when they do, they have to comply with federal guidelines. It was started in 1965, and it's to pay for healthcare when those individuals who cannot pay for it for themselves. The Center for Medicare and Medicaid Services administers the Medicaid program. And that is a subordinate of Department of Health and Human Services, and Ohio is part of CMS Region 5, located in Chicago. Generally, the federal statutes are an overall guideline, but the nitty-gritty of Ohio Medicaid is going to be in the Ohio rules and regulations. Ohio Department of Medicaid is the agency that administers it here in Ohio since July of 2013. However, the County Jobs and Family Services administers the Medicaid program at the local level. In looking at Ohio Medicaid law, there are some statutes, but again, the nitty-gritty is going to be in the administrative code rules, which for nursing home Medicaid generally are going to be in 5160 chapter or 1-3 and 1-6. Medicaid is categorical eligibility. And that means that it's based on an individual and that they must meet limiting physical factors. This is a difference from our community Medicaid, where we have the able-bodied can qualify just based on income. For institutional Medicaid, you must meet the limiting physical factor, be one of the categorical groups, which is aged, blind, or disabled. But if you're in a nursing home and you meet a nursing home level of care, which you must meet to qualify for home and community-based services, then you would qualify under institutional Medicaid. Now, there are many other eligibility criteria like citizenship we're not going to discuss. Our discussion is limited to the financial piece. As we go through, you're going to see lots of numbers, and the numbers change depending on the time of the year. Some change in January, some in July, some in October. Where can you find those numbers? If you go to ProSenior's website, and this is our general page, and you look at the resources tab, you click the drop down, you will see Medicare, Medicaid eligibility. If you click on that and you scroll down that page, you will see first Medicaid and resources and rules. You can click there. That will give you an actual list where you can link to the various rules. If you go back to our main page under Medicare, Medicaid eligibility, we also have a great chart that's very lengthy that lists all the numbers and when they change, both for 23 and 24, the last year and the prior year. And as you'll see, for instance, when we talk about the minimum monthly maintenance needs allowance, that changes in July, but the federal cap is in January, the shelter allowance is in July, etc. So when we're going through our analysis of Medicaid for nursing home Medicaids, we tend to use some acronyms or some language. Obviously, the Medicaid applicant is the person who's applying. But when we have a husband and wife, we usually call the spouse in the nursing home as the IS, short for institutionalized spouse. And the CS is usually the community spouse. We tend to use those as we go through. So as I said, we are talking about financial eligibility. And when you're looking at nursing home Medicaid, the key is really to take one step at a time, figure out which hat you're putting on first, and go through that analysis, and then put the next hat on. So when we talk about nursing home Medicaid, we'll look at the financial criteria that you must meet. We'll look at income eligibility and then resource eligibility. Never the twain shall mix. Okay, so you have to start with analysis of each one, and then under resource eligible, which we'll talk about in 2 weeks, you also get into the sub piece of asset transfers. But step one is to talk about income eligibility. So what is income? When we go through Medicaid, you always have to look at the rules and how they're defined. So income is cash, in-kind income, something of value received, available, and attributable. It includes earned income and unearned income. Earned income is wages, earnings from self-employment. Unearned income is everything else. You have to actually receive it to have it counted. But if you purposely say, I'm not going to take it till later, which could be, for instance, applying for your pension, they'll count, or Social Security, they will count it in the month that you could have received it. Potential income, basically the same kind of concept. You have to pursue collection of all of it when it's available. And if you don't, the presumption can be, rebuttable, but the presumption will be that you didn't pursue it because you want to be income eligible for Medicaid. Retirement funds. Now, retirement funds can be income and resources. We'll talk a little bit just here about when is it considered income. And this is a significant change. If your retirement fund, example, your IRA, is one in which you have set up regular guaranteed lifetime payments, then it will be considered income, and therefore the IRA itself will not be counted as a resource. Right? So you generally think of RMDs, or required minimum distributions, because that's easy to calculate what a lifetime payment is. But it's not required that you wait to 72. If you, as early as 62, set up regular monthly payments, and I don't think it doesn't even have to be monthly, but regular payments each year, that is actuarially, equivalent to what you would receive over your lifetime, then that IRA will be excluded as a resource, and instead the payments will be counted as income. In general, with regard to other retirement accounts, like your pension, for instance, you have to apply for the benefits when available. And the rule says you have to maximize those benefits, which includes requesting your community spouse to waive joint survivor benefits. Now, this is a serious problem with the federal law regarding pensions. It's called ERISA, because those benefits are guaranteed to the community spouse, and the community spouse must waive them. And it's really not a good policy that her survivorship benefits would be waived. So the answer to that is, if that situation occurs, the community spouse should just say, no, I'm not going to waive it. Right? They can't force the community spouse to waive it. But they might suggest it, and the answer is just, no, I'm not going to do that. And then document the refusal. So, to become income eligible. Now, this is the initial benchmark, okay? Income eligibility. And the IS is income, countable income, must be at or below what they call the special income level, or SIL. And that is equivalent to 300% of SSI. Now, in your slides, I had the 2023 number. That's why I've got it highlighted there. That is the 2024 number of 2829. Now, in the past, We were able to deduct medical expenses from your income in order to qualify. However, Jobs and Family, I should say, Department of Medicaid eliminated that, and you cannot deduct this. Hence, when you're in a nursing home, for instance, your cost of care could be deducted from your income, and you would become eligible income-wise. That changed. And so now we just look at the gross income of the individual in the nursing home. The CS's income is not included in that calculation, just the institutional spouse. Now, whenever we look at income or resources, as we talk about it later, there are exclusions. Exclusions are not deductions. They are exclusions, meaning certain things are considered not to be income. And so you may receive them, but they are not income. Okay, so generally, you can look at this regulation. There's a whole list of different things like German reparations, etc. Okay. The most common exclusion we see is the general disregard provided under Social Security of $20 and $65 under earned income. Then there's a separate list of income exclusions from the special income level for institutional Medicaid. And the main addition to that list is going to be your VA aid and attendance benefits. And again, we're talking for eligibility purposes. So let's look at this example. We're going to talk about Susie and Sam frequently through the next 2 presentations. Okay. So, or at least through today. Susie enters the nursing facility on February 1st. She's married to Sam, continues to live at the home. Susie receives $22,560 Social Security and $1,000 in a GE pension. Sam receives $1,250 in Social Security. They have $25,000 mortgage on their home, which has a payment of $550 a month. Their real estate taxes are $1,200 every 6 months. Their homeowner's insurance is $720 a year, $60 a month. Susie has a med sup policy, which costs $250 a month. This is sort of how you get those facts when you're talking to people, right? So the catch here is going to be what level are we at? Okay, we are at income eligibility, the first level. So we are now looking just at Susie's income, okay, and comparing it to the income eligibility limit. So individuals receiving long-term care services, Susie is in a nursing home, and her income is above 300% of SSI, which was $2,829. So she's not income eligible. What do we do? Well, there is this legal technique that's called a qualified income trust that was created many years ago. And essentially, what you're doing is that you're putting part of your income into this trust, so it's no longer considered your income. That way, your income is below the income level, the SIL or the income limit, and you are then income eligible. Okay. So the Ohio Department of Medicaid put this out when they created this qualified income trust for Ohio. Here are the key pieces that you must have. It must be used for income only. You cannot use this to put resources in, to exempt the resources. You can only put the Medicaid applicant's income or Medicaid recipient's income in there. So Sam's income can't go in here, only Susie's. You cannot put in family resources or the spouse's resources. It has to be irrevocable, meaning you can't cancel it. It has to be signed, and you must name the state of Ohio as the residuary beneficiary. And what it does is it allows whatever's left in the trust after you die to be paid to the state. So, key takeaways from that are you want a minimal amount in there. because whatever's left is going directly to the state of Ohio, up to the cost of what they've paid for your care. So you don't want to leave a big chunk of money in there. As we said, the income transferred to the trust is not countable for Medicaid income eligibility purposes only. Those are key terms: countable, okay, and income eligibility. It can only be used for institutional Medicaid eligibility, which includes the home community-based service waiver programs. And there is a form, and there is the link where you can find the QIT form. So I just have a couple of slides that show you what that trust document looks like. Okay. This is the state of Ohio's QIT form. Now, you can't take this to a bank and ask the bank to fill this out for you. Okay. The bank can notarize it, and the bank is required to set up the QIT account, but they're not going to fill this out for you. When you have questions about how to fill it out, what we'd recommend is that's a good time to talk to our helpline. Okay. And it sets out what the trust distributions can be for. So what can you do with the money once you put it in? Each month, you can pay it out to pay for your personal needs allowance, or, under the waiver programs, that could be a maintenance needs allowance. You could pay out the allowance for the spouse, and if there's any family members or family dependents, any medical expenses incurred for the primary beneficiary. And you can pay some bank fees, attorney's fees, and other expenses up to $15 per month. Okay. And then there's the trustee's duties. You can't transfer the trust assets, and it terminates upon the death of the beneficiary and the funds distributed to the Department of Medicaid. All right. And then obviously the grantor is signing this, the trustee is signing this, and there's a certification of trust. The second piece of that is going to be the verification form, which of course is located somewhere else. And that is something the bank is going to fill out, or you're going to fill out with the bank, showing where the account is set up. So the QIT process in summary is you have to create the QIT by filling out the form. You open up an account. Now, not every bank will do a QIT account. So you have to sometimes call around for that. But you open up that account and you make a deposit into the account. You provide the bank account information to the JFS, and then you make monthly deposits into and out of their QIT account. What's preferred is auto deposits and auto withdrawals. Okay. So in our case of Susie and Sam, you're putting some of Susie's income in there, and you're just doing an automatic withdrawal out of that account back into Sam's account for his monthly income allowance, assuming there is one. Okay. If you're using it to pay the nursing home, then you're doing an auto withdrawal or writing a check to the nursing home every month for the amount that's in the QIT. Obviously, you can have a $15 deduction to allow for trust account fees if the bank charges those kind of fees. And then the state will look at your transactions every year and basically look at your bank statements. How does this now affect patient liability? Okay. It doesn't. Okay. So when you're figuring what gets paid to the nursing home, okay, or to the Council on Aging, the passport provider, et cetera, it has no effect whatsoever. Okay. It is now counted for post-eligibility calculations. So when we move to patient liability, we take off our income eligibility hat and put on our patient liability hat. Okay. the income that's deposited into that QIT account is the same, is still counted for post-eligibility calculations. All right, so let's take a look at our example of a QIT. Remember, Susie enters the nursing facility on February 1. She's married to Sam, who continues to live at home. She receives $2,560 Social Security and $1,000 in a GE pension. Sam receives $1,250 Social Security. They have a mortgage. They have taxes. They have owner's insurance, and she has a med sup policy, which costs $250. So in our case, this might be our first poll question. Yes, it is. Okay. So if Susie must deposit her pension in the QI. So if you want to fill that out, let me see if it'll let me go back to yours. There you go. There's your sample of our facts. So take a minute, see, and answer which one of the 4 is appropriate. Then we'll talk about it.
Mary, how does it look for the percent that have responded?
We had about 75% so far.
Okay.
Okay.
Let's give everyone 10 more seconds and we'll shut it down. Okay. Mary, do you mind sharing the results? Miriam, can you see this?
Yes, I can. Cool.
Great.
So let's go through the analysis here. Okay. So the correct answer is she must deposit her excess income above the 2029 into the QIT. Okay. All she needs is to reduce her income below $2,829. Okay. So the first question, must she deposit her pension? She does not have to deposit all of her pension. However, perhaps because of the number that you come up with as to what she needs, okay, that's an easy answer. All right, she only needs to deposit about $785. But maybe it's just easier to deposit her GE pension directly into that account. That's perfectly fine. Okay, it is not required. Okay, must she deposit her Social Security? Again, the answer is no, because she only needs to deposit the excess income above the 2890 number. Okay. Does she need a QIT or she does not need a QIT? Well, Susie's income is $2,560 plus $1,000 in GE pension. You do have to add those together. That puts her income at $2,560. I'm sorry, $3,560, which does put her above the 2890 number. Okay, so great, guys. I think you got the idea. Okay, and again, when we say the excess income, it may be wise, practical question wise. That you want to put in something more. And see if I've got my slide. My numbers are in there already. Okay. You're only looking at Susie's income. Okay. And she's over the limit of by $731. She only has to deposit the amount that gets her below $2,829. But also remember, when they give you numbers, frequently they will give you the Social Security number as what they receive frequently that's deducting Medicare premiums. You have to use the gross number before Medicare is deducted from their income in order to calculate the amount that should be deposited in that QIT. Because if you don't deposit enough, then you are not income eligible. Okay. So it's a good practice to deposit extra. Maybe the $1,000 a month is the easy solution. Okay. All right. So questions on QIT. This is my first question. We'll break here for questions.
Yep, we have a couple. I think they came in before maybe you got through the whole QIT session. So
Sure.
You might have answered these already, but maybe just for emphasis.
Sure.
We have a question: at what point in the application process do you create the QIT?
Okay. So you can create it any time, but the catch with the QIT is that you will not get retroactive coverage. Okay. Because it's based on income eligibility, you must create the QIT and fund the QIT in the month that you want coverage. Okay. So for retroactive coverage, meaning you apply in 1 month and you can get coverage for 3 months prior to that, you will not be income eligible in those 3 prior months. So yes, if they are over income, you must set it up and fund it for the month that you want coverage.
Okay. And then next question: how does the state collect the funds after the IS passes away?
They usually will contact the bank directly, okay? Or the bank will contact them to pay it out.
Okay. And then we have a little bit of a scenario, if it's okay. Jennifer asked, if client is set to receive tax refund of approximately $4,000 because of a PERS disbursement that was spent down in the prior year to preserve eligibility, but they accept only 50% and defer 50% for the following tax year, is the remaining $2,000 considered income because they could have received it?
The answer is no. Okay. It's the tax refund is usually considered as a resource, but I think it's also an exempt resource. So it is not counted as income.
Okay. One more question, it looks like. Is there a limit to the amount someone can take out of the trust for personal needs, similar to those getting a set amount to use while living in long-term care?
Okay. So that will get into our income calculations. When they're talking about personal needs, they are talking about your personal needs allowance that's calculated into what your long-term care is, okay, or what your patient liability is. So that is set at $50, but on the waivers, there are different numbers, and we will run through each one of those, but that's what they're talking about, as well as the monthly income allowance for the spouse and the patient liability that you're paying to the nursing home. So that's exactly where we're going next.
Okay, that looks like it for questions at the moment. Thanks.
All right, great. All right, so now let's talk about how we calculate patient liability. Okay. Just as we already talked about, the QIT, you're not eligible until it is in place and funded. Then when you're income eligible, we are going to consider the income to determine patient liability. Just like we did with the other income eligibility, now for post eligibility, there's a whole list of income exclusions. Okay, and again, there's a huge list. One of the ones we look at, remember, under eligibility, aid and attendance was excluded entirely, but for patient liability, only VA pensions up to $90 is excluded, i.e. not counted as income. Those are the general ones, but there again is the rule to look at all of them if you have some of those weird kind of pensions. Those are the big ones that we usually see. VA pension is based on financial need, and that's why it's a little different than pension from GE, for instance. Okay, so when you enter a nursing facility, the VA pension should be reduced to $90 per month. Okay. But whenever it is, the first 90 is considered not income. Okay, so it's an exclusion. What about deductions to income? Gross income is counted. So child support or spousal support that's being taken out of Social Security, still going to count the gross income, not going to deduct for that. Other court ordered deductions, taxes withheld, garnishment orders. So, the discussion about student loans, and you have someone's Social Security being garnished by the federal government for student loan payments. For Medicaid, they're going to count the gross amount. We've had questions about, well, what about paying the mortgage on their house or the rent on their apartment? And the answer is your patient liability is going to be based on your gross income. There is no deduction for those either. So how do you calculate patient liability? And this formula in your handouts is going to be in there once, but I am going to repeat it several times as we go through various examples. So you're going to start with the gross income of the EIS. You're going to take out what we're talking about, excluded income first. You're going to take off the personal needs allowance, which for nursing homes may be $50, but for a passport is different. And the assisted living waiver is also different. We will talk about that. You're going to deduct a monthly income allowance for the community spouse. There's a deduction for a family allowance for dependent family members. You're then going to deduct health insurance payments. And then you're going to deduct unpaid medical expenses. If you have a QIT, bank fees up to $15 a month. It's not automatic. It's whatever the bank is actually charging with a cap of 15. And that's your patient liability. So in your normal calculations as to patient liability, the first thing we see here is MIA for community spouse. You're saying, what is that? Well, that's the first step in calculating in order to determine what the patient liability is. Now, patient unpaid medical expenses, just to highlight for that quickly, it's going to be applied to your patient liability first before any payments to the nursing facility, and you can choose which months to apply the UPME to the patient liability. So, what is the monthly income allowance? How do we calculate that? There is the triple MNA we call, which is the minimum monthly maintenance needs allowance standard of $2,465. This is a number that changes every July. You add to that an excess shelter allowance. You compare that to the federal cap, which changes in January of $3,858, and use the smaller. If the actual is higher, you would have to request an administrative hearing to establish extraordinary circumstances. From that number, you're going to subtract the community spouse's income to come up with that spouse's monthly income allowance, that part of the IS's income that the community spouse gets to keep for the community spouse's needs. Okay. So again, looking at this calculation, what you don't know is what is the excess shelter allowance. So your first step is to calculate the ESA. How do you do that? You're going to total the community spouse's expenses for the residents: mortgage, rent, property taxes, homeowner insurance, HOA fees. Add this utility allowance, assuming that the spouse pays some form of utilities, even if that's telephone service. And then you're going to subtract a standard number of $739.50, which again changes in July. And that is the excess shelter allowance that the community spouse is going to keep out of the, because it's going to be added to the monthly income allowance of the community spouse. So we now know what the ESA is. We go back and calculate the MIA to come up with patient liability. So let's do an example again. This is our example we talked about before. We know Susie's income Now we're gonna look at Sam's income, and we're gonna look at all these other numbers I was giving you before. The mortgage payments, the real estate taxes, the homeowner's insurance, Medicare supplemental policy. So again, looking at our formula. Okay, in Susie and Sam's example, okay, we don't have any excluded income. We don't have a family or allowance, okay? We don't have unpaid medical expenses. We may have QIT payments, right? All right, so let's go first. Step, what we said is to calculate the community spouse, which again is looking at the standard, adding the excess shelter, subtracting the community spouse's income to come up with Sam's MIA. And in order to do that, we have to calculate his shelter costs, add the utility allowance, subtract the standard. So in Susie and Sam's situation, they have a mortgage of $550. They have real estate taxes monthly of $200. They pay insurance of $60. So their total shelter cost is $810. And he pays utilities. So that means it's $1,534. We deduct the shelter allowance to come up with the excess shelter allowance for Sam. We're going to take that number now and put that into our monthly income allowance calculation. So we take the standard and we add the excess shelter allowance we just calculated. This is the triple MNA for Sam, which is $3,259.50. It is lower than the cap, so we're going to use that number. We're deducting Sam's income. So the monthly income allowance for Sam, the amount of Susie's income Sam may keep, is $2,009.50. So now we go back to our formula. We have all the numbers now. Put in the gross income, gross countable income for Susie. It's over our QIT limit. So we probably have a QIT bank fee. Susie's in a nursing home, so her personal needs allowance is $50. That leaves her available income of $3,495. We deduct those Medicare supplemental insurance premiums that she pays, and we deduct Sam's monthly income allowance. So what Susie is entitled, or Susie owes to the nursing home, is $1,235.50 out of her $3,560. With regard to what the question earlier about the QIT, what can she deduct out of the QIT? She can deduct the $50. She can take out the $2,009. She could take out the $1,235. All of those, any of those can be deducted each month. But all we're putting in there is that $780, or maybe we're doing the pension of $1,000. Then it's easy. In this case, his monthly income allowance is $2,000. What's going into the QIT is $1,000. You put the $1,000 in at the beginning of the month. You transfer it back to the community spouse's account as part of his MIA. Now, how does this change if we're talking about passport, for instance? Does she need for a QIT for income eligibility, and how is patient liability calculated? Well, income eligibility is the same as for passport as it is for nursing home. Therefore, again, to be income eligible, Susie's income must be below 300% of SSI. And if not, a QIT must be used to qualify for passport services. How do we calculate the cost share on passport? It is going to be exactly the same as for nursing homes, with the only difference being that the personal needs allowance for passport is now $1,839 a month. So back to our example that we've been looking at, except now Susie is applying for passport. How do we calculate it? Here's our formula. that we've gone before. Susie's gross income, taking out, she doesn't have any excluded income. But now instead of 50, we're going to deduct the SIMNA for passport. We still have to calculate Sam's monthly income allowance. So even though they're living at the same home, in passport, he is still entitled to that monthly income allowance. We're deducting the health insurance premiums and the bank fees to come up with her cost share under passport. And again, to do that, we have to calculate Sam's MIA, exactly what we did just a minute ago. We're taking the standard, we're calculating the ESA, we're subtracting community spouse's income. That means to come up with Sam's MIA. And in order to count his ESA, it's exactly what we did immediately before. Again, we're totaling up all the principal residence expenses. We're adding the utility allowance. We're subtracting the standard to come up with the excess shelter allowance. We put it into our example, still the same. Mortgage, real estate taxes, insurance, shelter costs, $810. Utility allowance, $724. Deduct the allowance standard. This is the ESA for Sam of $794.50. We put that into our calculation now for his monthly income allowance. We're taking the standard number and we're adding that allowance we just calculated to come up with his standard, $3,259.50. We deduct Sam's income. So Sam's MIA still the same, $2,009.50. Now we come to the change. Susie's gross income is $3,560. We deduct the bank fees. We deduct the personal needs allowance under passport of $1,839. Now Susie's available income is $1,706. We deduct her med subs and Sam's MIA, and her share of costs now under passport is $0. Now, passport program does have a limit. There is a cost cap of services of $14,700. And if the cost of care is too high, they will be denied enrollment. Now let's quickly talk about assisted living waiver. This one is slightly different, but similar to passport. This is an home and community-based services program, waiver program. And so income eligibility will be the same. Similarly, the patient liability will be calculated the same, except for the P&A under the ALW program plus room and board, because Medicaid does not pay for room and board. So how is room and board calculated? There is an allowance for SSI costs, which is allowed at the SSI rate minus $50. Therefore, frequently you'll see a shortcut to saying the P&A is 50, but technically it is a P&A of 50 plus your room and board. Again, looking at our facts, this time Susie goes into the assisted living facility and applies for the waiver. Same formula that you've heard me say a couple times now, okay? We're taking Susie's gross income. She doesn't have any excluded income, but now the P&A is going to be the assisted living waiver allowance. Okay. And we're still deducting Sam's MIA. We're still deducting health insurance premiums. We are also deducting QIT bank fees to come up with what Susie owes to the assisted living facility. So to do that, we have to calculate Sam's MIA. It's going to be exactly the same formula. Taking the standard, subtracting the excess shelter, subtracting his income. In order to do that, we have to calculate what the excess shelter allowance is. So we're adding up all those expenses. We're adding the utility allowance. We're subtracting the standard. That gives you the excess shelter allowance for Sam. We put that into that same formula that we did before to come up with his allowance of $794.50. Then we calculate his MIA, which is $3,259.50 minus his income. Again, the MIA exactly the same for the assisted living waiver. So then we come to the final calculation. Susie's income, $3,560. We're deducting the bank fee of $15. We are deducting the needs allowance of the assisted living one, which is SSI rate, $943. This makes her income is now $2,602. We deduct the bank, the med sup and the MIA to come up with her patient liability of $343. However, she also must pay room and board to the assisted living facility, which is the SSI minus 50 or $893. So she's going to owe the facility $1,236. Questions on patient liability calculations? And hopefully everybody's not asleep yet.
I see one question, Miriam.
Yes.
Can my care individuals use a QIT?
So, when my care is just sort of, in order to qualify for my care, that's generally if you're dual eligible in the community and you're not on a home and community-based waiver program. Now, if you are on a home and community-based waiver program through my care, then you would use the QIT, but you cannot use it to, for instance, qualify for the Medicare premium assistance or something like that. Okay. So my care is really, I mean, it's basically private care for Medicare and Medicaid programs when you're dually eligible. But if you're in a my care program, that's basically, passport, but paid through managed care, okay, you're going to use the QIT. Okay.
All right. That's all the questions I see at the moment.
Great. So Medicare premium assistance programs, just a highlight of that. Okay. These are separate programs through Medicaid to pay Medicare premiums for incomes up to 100% of the FPL, federal poverty level. If you are in the SLMB or QI program and your income is up to the federal poverty level of 135%, they will just pay your premiums. If your income is up to 100% of the federal poverty level, they will pay your premiums and your copays and your deductibles. However, in doing that, compare the income of the individual and the spouse and any dependent or minor children to the federal poverty level for that size family. Previously, Ohio would only consider the individual, would count all of the income and compare that to the FPL of 1. But in this case, that has been changed. So the income of the individual and the spouse has to be compared to the family size, the federal poverty level for the family size. In that case, maybe 2. But if it's a disabled mother, for instance, with 4 kids, you're going to compare her income to the federal poverty level size, income level for 5, for instance. Okay. All right. Any other questions on income eligibility at this point? If not, I'm going to move into resource eligibility. Okay. So you guys are all experts on income eligibility. So let's talk about resources. Okay. So take your income hat off. Now you put your resource hat on. Okay. This is going to be a process. We're going to start with an assessment Then there's going to be an allocation between husband and wife. Then there's a spend down. And if the resources allocated to the institutionalized spouse exceed $2,000, you have to spend down to that $2,000. You are resource eligible once the IS's resources are equal to or less than $2,000, and that is in the last day of the month that you hit the $2,000 number for resources, you will have eligibility for that entire month. So here is a spreadsheet, the steps that we will take. The first one is going to be determining the snapshot date. Then you are going to list all the resources. You're going to, like we did with income, but now we're looking at excluded resources. We are going to take those off the list. And then we're going to talk about non-accessible resources. Then we're going to allocate them between husband and wife, spend under $2,000 to become Medicaid eligible. We are going to today talk through number 4. And then in 2 weeks, we will do 5 through 8, as well as asset transfers. So the first thing on here is the snapshot date. And the question is, what is a snapshot date? Well, this is the date we're going to determine the value of the community spouses, the IS and the CS's joint resources. So the assessment is the process where we combine the resources of both IS and CS. So you'll recall under income, we're only looking at Susie's income for eligibility. Under resources, we are looking at both of their assets, and in order to determine the countable resources. Okay, so again, that's a key. Countable resources is what's left after deduction of all excluded resources, which we will talk about. Okay. And the date we're looking at is the beginning of the first continuous period of institutionalization. So a couple of caveats. One, there's only one resource assessment done per individual, regardless how often you apply for Medicaid. So you get denied, and then you come back and apply 3 months later. They're not going to redo the assessment. Caveats: Department of Medicaid only accepts the date if you lived in a different state. They will apply Ohio's laws to your joint assets as of that date, however, regardless of what may have been determined in Kentucky or Indiana or West Virginia. Can a prenup or other agreement be counted? Oh, I owned all this property before we got married. It's solely in my name. The answer is no. Well, I had a prenuptial agreement saying it was all mine. For Medicaid purposes, they're going to count it. So what date are we looking at? This is what we call the snapshot date. This is the first day of the month in which the IS was in a medical institution for a continuous period. The first day of the month when he is expected to be in a medical institution for a continuous period, or the day they apply for home and community-based services. So you're looking at the day they entered in for 30 days. First day they were in for 30 days. That's the date we are looking at to list what resources they have and value them. Okay. Now, for those who are going to apply for passport or assisted living waiver, the date that they're going to look at is the date they apply. And the only question is not whether they're going to qualify financially, but do they meet the intermediate level of care that you have to meet for HCBS services. Okay. So our example, Joe is admitted into a nursing home February 1. He's married, and his wife privately pays for 2 years. As their savings dwindle, she becomes concerned and applies for Medicaid on February 1, 2024. What is the snapshot date? And I think that's our poll question number 2. We got to add another poll question in there to see if you're awake. All right.
Mary,
So
do you have-
yes.
Oh, is the question up? I'm sorry, I can't see it. but-
Yes, the question is up. Yes.
Great.
And there's our facts if you need them.
We have a little over half who have answered.
About 30 more seconds and then we'll shut it down. Okay. And are you able to share the results, Mary?
Okay. So some said 2024, some said 2022, some said 2023, and some said, I don't know what a snapshot is. Okay, so our snapshot date is the date that we're going to look at to value Joe's and his wife's assets. That date is sort of taking a snapshot in time of what they owned and what they were worth on the date that Joe was first in the nursing home for 30 days or expected to be 30 days. In our example, he went into the nursing home on February 1, 2022. Therefore, his snapshot date is February 1 of 2022. Okay. That is key, right? Because she's been spending down, so they may be resource eligible, but when we're calculating those resources, we have to use the proper date. Sorry, guys. Oh, I didn't have it. Okay, so sorry. All right, so what is the problem with doing that? She doesn't apply until February 1 of 2024, but he's been in the facility for 2 years where she's privately paid. She has to come up with the values of her assets 2 years ago, and that's going to be needed to calculate her share of the assets that's going to be allocated to her, which we will talk about in 2 weeks. Okay. What's the problem for our elderly clients? Okay. Is that, gee, they might not have the records. We're happy if we get their bank statements from yesterday or last month, right? I had a case in which she literally paid for 4 years, and they owned at the time some AT&T stock that had been changed, just a few shares, changed to all the baby bells all over the country, which had also changed names 3 or 4 times. And coming up with the value 4 years ago was a challenge. So it is, if the date they apply or the date they go into the nursing home is going to be the day that we want to look at what those assets are and start collecting those documents, because it's very difficult to figure out 2 years later what those might be. Okay, so step 1, we've determined the date. Then we're going to look at listing all their resources. Okay, so once again, definition: resources are funds held with a financial institution, basically anything that the individual or the spouse has an ownership interest in and the legal ability to access in order to convert to cash. Okay. And then countable resources is everything that remains after all exclusions have been applied. So we're going to list everything they own that they can convert to cash. And then we're going to deduct the exclusions, which is what we're going to talk about next. So we talked earlier about retirement funds as income. When are they resources? Basically, if they're not income, they're resources. Does the IS or the CS have an ownership interest and the legal ability to access in order to convert to cash? Why is that key? What if this is like a 401k and the community spouse is working and they cannot access them? They're not allowed to make any withdrawals while they're working. They have to retire in order to access it. Okay, then it's not a countable resource because you can't access it. Retirement funds, examples of those, profit shares, IRAs, pensions, defined benefit pension plans, etc. So we've listed all the resources. Now we're going to decide which ones we scratch off the list because they're excluded. So an automobile, regardless of the value, so long as used by the resident or a member of the family for transportation. If there's a community spouse, regardless of value or use. Household goods. Generally, yeah, you convert them to cash, but they're not going to be worth anything. So for the most part, we don't worry about household goods. Burial space. Now, the burial space is basically an exclusion for the individual, the spouse, or any member of the immediate family. But again, got to look at that definition. We're going to talk about that in just a minute. Also, how is a burial space defined? It includes the plot, but it also includes the crypt, mausoleum, casket, urn, niche, a contract for care of all of those, including vaults, headstones, markers, caskets, opening and closing of the gravesite. All of that can be prepaid as part of a burial space exclusion for the individual spouse and members of the immediate family. Here's our definition of what's immediate family. Parent, adoptive parents, minor adult or adult children, adoptive and stepchildren, siblings, adoptive and step siblings, and spouses of the same. Can all be, you can spend the money on purchasing plots for all of them, and it's excluded. And then we have a definition of agreement, basically means a contract for that specific individual. Now that's different to your prepaid burial contract. So we have the plot exclusion, and then we have the prepaid burial contract, which is an irrevocable burial contract. And this is limited to the IS and the CS. If you're using life insurance, you must irrevocably transfer the ownership of that policy to the provider of the funeral services. Then we have a nice little extra exemption, which is called burial funds. This is $1,500 each for each. The IS and CS can be excluded as burial funds. And it's basically held in a revocable burial contract or a burial or revocable bank account designated for burial funds. It has to be designated for that purpose, has to be kept separate. But again, this can be any kinds of sort of funds on deposit for burial, okay? That's in addition to your irrevocable prepaid burial plans. Life insurance, there's an exemption for life insurance that if the you count the cash value, in other words, what you can get if you cash the policy in as a resource. However, if all of your life insurance policies for the face value is under $1,500, then you exclude the cash value. These are more of like the baby policies where you know, the residents or the ISs or CSs mother bought them something when they were 2 and they're now 70. And so the face value was $1,500 and there's a cash value in that, it could be $5,000 or $6,000. We don't count that. But if all the face values of all the insurance policies is over $1,500, then they count the cash value. And then dividend accumulations are countable. Now comes to our main exemption, and that is the home. The home includes any appertaining or contiguous property that the individual has an ownership interest in, and it has to be your principal place of residence. This is defined the dwelling that the individual considers their home and to which, if absent, they intend to return. So, note that intention is not the objective. They're not going to be able to go home. That's not the question. The question is, do they intend to return home? So, if the Fountain of Youth were found tomorrow, or the miracle cure were found tomorrow so that they could go home, would they intend to do so? Generally, yes. It is totally subjective. It is not an objective test. Only one place can be the principal place of residence. So for our snowbirds who may go down to Florida for 6 months, they have to designate which one is their permanent home. The value of the home then would be excluded if it is the principal place of residence of the ISCS or another specified family member, and the deed is in the home of in the name of either of them, or even in a revocable trust for either. So you may see a deed that says Susie Smith, trustee, still going to be exempt. When is it no longer considered to be their principal place of residence? Is if they do not intend to return home, and they provide a statement of their intent, okay? And they can't have established a permanent place of residence elsewhere. So it raises the question, if you move into assisted living, have you established a permanent residence elsewhere? Not something that's been answered at this point. Well, let's say they don't intend to return home. It's still not countable if the spouse or dependent relative continues to live there. And dependency can be of any kind, financial, medical, etc. Okay, so in our example where Susie went into the assisted living facility, Sam is still living there, still going to be exempt. Again, what I say, you always have to look at definitions. For the home exemption, a relative means child, stepchild, grandchild, parent, step-parent, grandparent, aunt, uncle, niece, nephew, brother, sister, step-brother or sister, half-brother, half-sister, cousin, or in-law of any of the above. So you have the situation where they've gone into a nursing home and they're not going to intend to return home. The deadbeat cousin moves in. The home continues to be exempt, right? Does not have to be disabled or anything else, just has to be a dependent, i.e. dependent on living there because they have nowhere else to go and can't afford to do so otherwise. Then there is also a hardship due to the loss of housing for a co-owner. So this could be the long-term partners, for instance, who never really got married. The partner in that case could still see the home exempt because they must provide a signed statement that they use the property because they live there, and they would have to move if the property were sold and they have no other place to live. So if there's a case of domestic violence, or again, there's essential for self-support, usually a basic minimal rental income kind of situation, still can exclude it. Now, with regard to the exclusion, however, there is a cap, a home equity limit, which also changes every year. Currently, that is $713,000. If for some reason they had that case, again, we're talking equity, all right, meaning after you deduct costs of mortgages or liens, okay? So the way to beat that, if that situation comes up, is look at a reverse mortgage or home equity loan to reduce the total equity interest. But again, that would not apply if the CS is living in it, the child is living in it, who is under age 21 or blind or disabled. So if you have one of these exclusions, you do not have to worry about the home equity limit. Then there is also a hardship exception for the home equity limit if the denial of coverage would deny you medical care or food, clothing, or shelter, or other necessities of life. So let's go through the summary quickly of the home exemption, which is probably the biggest one we look at. It's exempt if the IS intends to return home. Even if they don't intend to return home, their spouse or dependent relative lives there, or a co-owner lives there and there's undue hardship, or they left because of domestic violence. What if the property is no longer the principal place of residence and no exception applies? Real property is excluded now, so long as they put it on the market. Okay. For sale at an amount equal to the fair market value determined by the county auditor or another knowledgeable source. So we have a fairly new regulation where if the real property is pending for sale, they can be qualified for Medicaid while it's on the market. They have to provide documentation that the property is not sold to do something to do with the property. Basically, oh, it's on the market, it hasn't sold. Is basically what you're documenting, okay? Note the knowledgeable sources, county auditor, can be brokers, agents, appraisers, it can be lending institutions, numerous different things, not just the auditor. Obviously, the auditor is the easy one. You show that an actual but unsuccessful sale has been made. Again, you have to show that it has been and is currently listed for sale. This can be in the newspaper or for sale by owner sign or website with the agent, broker, etc. It has to be listed for an amount equal to the fair market value determined by the knowledgeable source. And you haven't refused, or basically what's a reasonable offer? A reasonable offer is our 90% rule. It is presumed to be reasonable when it is not less than 90% of the fair market value. If it's less, then you're supposed to look at it, say, well, maybe the value is wrong. If it's incorrect, either the individual or the agency may obtain an appraisal for a more accurate value. But if it's so low, then, then we know it's unreasonable. And the individual can rebut the value by showing an appraisal. So we have the flipper where they sell it for less than, or they're looking at selling it for less than 90%. We need some documentation that it's a reasonable value. Even in the case where you can't list it for some reason, you produce documentation of a good cause exception. So for instance, maybe, a tenant is in there and you can't list it because they're, they threaten the realtor every time you come around, that kind of thing. Good cause is when the individual was prevented by circumstances beyond his or her control for listing the property for sale. There's the similar rule for personal property, which may be difficult to sell. So looking at an example, Julie Jones enters a nursing facility. She owns her home worth $100,000 free and clear, $2,000 in a checking account, and she owns a 2006 Ford Focus. So right now, we know she is eligible, right? She needs a statement to intend to return home. Her accountable resources under $2,000, and the car is exempt if it's being used for transportation. Julie's impoverished cousin James continues to live in the home, although the home is in her name. She is able to direct. She does not want to return home. Well, the impoverished cousin's living there, so the home continues to be exempt. She also owns real property in Kentucky, which is listed for sale. So our next poll question: Julie must sell her Kentucky property before she becomes resource eligible for Medicaid. True or false?
We are up to 70% of participants.
All right. Give everyone just a couple seconds and I think we can close it.
All right.
Okay, so half said true, half said false. So the answer is false, okay? Because she must list it for sale. She does not have to sell it, okay? She becomes resource eligible when it is listed for fair market value, okay? What about if the Kentucky property was her principal residence? Generally speaking, that's still not going to work because for Ohio Medicaid, you have to be a resident of Ohio, which means you must establish your residence in Ohio and you can't be a resident of Kentucky. So the solution is list it for sale. As long as it is listed for sale for fair market value, you are eligible for Medicaid. Okay, until such time as it's sold. Now, once it's sold, you have money and you're going to be over 2,000. The money is going to count. But while that property is on the market, you are eligible for Medicaid. All right, great. Now, with regard to partnership for long-term care insurance, there is a special exemption that allows qualified partnership policy payments to be excluded. So if you have $2,000, that's the maximum countable research that you can have. But if your partnership policy pays $100,000 towards your care, then your exemption is for resources is now $102,000. So quickly, our resource summary: car, household goods, burial spaces, prepaid burial contracts, life insurance where the face value is less than $1,500, the home, and any property listed for sale at fair market value, and long-term care insurance payments. Cool. All right. I'm going to quickly go through non-accessible resources. I know you probably get some questions, but let me finish that up and then we'll do questions at the end. Okay. Non-accessible resources. These are also going to be excluded, even though they don't fit under one of those categories we discussed. Non-accessible means you have the legal ability to access in order to convert to cash. So this could be two problems. Requires legal action to access, or you cannot access due to physical or mental impairment. You should identify the problem and list the efforts taken and ask JFS for help in any of those kind of cases. So shared ownership, if your co-owner is spouse, so you're saying, I can't list it for sale and I can't liquidate it because my spouse or child won't agree. The presumption is that you are able to sell it if it's The co-owner is your spouse or child. If the owner cannot be located, so you've been separated for 50 years and spouse is on the title and you can't find them, the cost of legal action is prohibitive, or you're unsuccessful, then you can exclude a shared ownership. What about physical or mental impairment? When that impairment substantially limits their ability to access the verifications or the resource, the agency is to determine another person is available with obtaining the verifications. If no person is available to assist, they are to refer the case to legal counsel to request an evaluation whether the matter should be sent to probate court or APS. But the caseworker is to note in the case record what cannot be available, what is not available, and must not be considered as a disqualifying factor until you can access that. So this comes from litigation that Procedures has engaged in, and we get this frequently where we have an incompetent client and they may have a bank account or property and nobody can sell it, or nobody can access it. And the answer from county JFS is go get a guardianship. Well, who's applying? The incompetent individual is applying. You cannot require the incompetent individual to get their own guardian. This would be, and is an ADA violation, to put those barriers in front of someone who has a physical or mental impairment. So we had a case in which our 80-year-old client was on passport and she had a life insurance policy that went above the cash limit and they terminated her. She did not have a power of attorney. She could not sign a release. She could not transfer the property to the funeral home. Similarly, we had a client who was 104, whose son was power of attorney, had a bank account. He died. No one could access the bank account. This rule ensued because of our federal litigation. So in that case, you have JFS saying, go get a guardian. The answer is to document the physical or mental impairment and that we cannot access it. They are to disregard those resources or income and determine eligibility without considering them. Essentially, put them on Medicaid. Okay? So, determine eligibility without considering the eligibility factors that cannot be obtained. And then you look at it again every year. Okay, questions?
Yes.
Yes.
We have a couple.
Yes.
In the Q&A, someone asked, are term life insurance policies, regardless of face value, countable or exempted resources?
Well, term life insurance policies have no value. They are not convertible to cash. So therefore, they are not a resource. Okay. It's not an excluded resource. It's just not a resource because you can't turn it in and get money for it. Okay.
Are there restrictions on how to use the money the person gets in a reverse mortgage situation counted?
Well,
or are there restrictions? I'm sorry, I said resources. Are there restrictions?
Restrictions, no. But if it's sitting there in an account, you may have some issue with regard to that, but no. Generally, it's set up as what we call a line of credit that you can draw on, but because it's a line of credit, it isn't necessarily an asset. But generally speaking, you're going to take those funds and use them for whatever you want. It's part of our spend down. Okay. But for reverse mortgage purposes, there's no restrictions. Okay.
I think the last question is similar to that one. I'll just read it in case I'm missing a part of this. If the family obtains a reverse home equity mortgage, which is paid in cash to the IS/CS, are the funds part of the countable resources? How might they spend the funds to qualify?
Yes. So if you get it as a cash payout and it's in their hands as cash, it is, something that they can access and use. Okay. They can spend down just like they would spend any other resources, and we will talk about spend down in 2 weeks. So come back on April 22nd for part 2. We will also have one of our presentations in October on reverse mortgages. So thank you, everybody. Just wanted to go through again our legal helpline. And there's our phone number, free legal advice for any senior or any of our social workers on behalf of our seniors. There's our phone numbers for this helpline. Then our Mid-American Pension Rights Project, their phone number. And then we have the Senior Medicare Patrol, where volunteers help with Medicare fraud and scams. And that's their number. That is also statewide. And then part of our service is our referral service. So we do have a statewide referral service to private attorneys, some who will work on a reduced fee based on income. So those are our services. Any other additional questions? And there I am, like right on time, but I appreciate everybody who's joined. I'm hoping that's helpful. And again, the PowerPoint that you can print off is there for you to sort of go back and reference, especially for, I know our social workers and ombudsmen who are attending, you're like, yeah, well, this is way more detail. But that is something for you to be able to reference when an issue comes up. Okay. And then more specifics, that's what our helpline is for our legal aid attorneys across the state. Again, appreciate it. Hopefully this is helpful to all of you. And hope to see most of you again in 2 weeks.
Yeah, thank you, Miriam. Lots of thank yous in the chat from the attendees. So
Thank
we
you.
appreciate it. And we, hope to see you in 2 weeks. We'll send some follow-up information once we close out today.
Great.
Thanks, everyone.